Yeah, never bet yourself on. Two things you want to do: hear your recording of your voice, or look at yourself on the live camera.
All right. Good morning, everyone.
Morning, Judge.
Morning, Your Honor.
Ms. Rivers, are you able to hear me?
Good morning. I can hear you.
Great. Good morning. We're going to get started, and we'll get on the record. We'll bring the Adamses out in a minute. I just want to get us on the record and understand what we're doing today, and then we'll certainly get both Isaiah and Leon Adams out here. This is case 16SC147814, State versus Adams and Adams. This is a hearing on motions for new trial that have been filed by both defendants. Mr. Armstrong, you're handling this for the state?
Yes, sir.
Great. Good morning. And Mr. Scarborough, you represent Leon Adams. Is that correct?
Yes, sir.
Great. And Mr. Strobel,
Yes, Your Honor.
I don't think we've ever met. Nice to meet you.
Thank you. Nice to meet you, Your Honor.
And you represent Isaiah Adams.
Yes, correct.
And we have Mr. Hudson here. Great. I think we have everyone we need. Mr. Scarborough, do you need to speak with your client before we bring him out, or are you good to go?
I think we're fine to go, Your Honor.
Okay, Mr. Strobel?
I spoke with him yesterday at the jail, Your Honor. I think. we're
Okay,
good to go.
thank you for doing that. Deputy, how do you want to arrange the people? Because we're going to have two defendants out here.
So, nope, I can sit here. You can sit.
Okay.
You can sit here. Oh, okay. Your Honor, may I hand up to you some transcript excerpts?
Sure. You got them to Mr. Armstrong as well? Great, thank you.
One other question. My colleagues want to know whether we're going to be YouTubing.
It's already started.
Already started. My colleagues are now informed that we are YouTube.
Hello, colleagues.
Leon?
Right there.
All right. Good morning, Leon Adams. And good morning, Isaiah Adams. I just got on the record before you came out here, who's representing whom, and make sure everyone's ready to go, and we are. What I'm going to do is share with you, Mr. Scarborough, and you, Mr. Strobel, what I think the grounds are you're pursuing, so you can let me know, yes, we're still pursuing those, or we're withdrawing them. At least one of them was tentative. You had indicated, because you didn't have a transcript at the time, so this was long ago, Mr. Scarborough, that maybe you were pursuing one. So we'll start, since you're closer, the Leon Adams grounds. One, insufficient evidence. Two, that Mr. Hudson had a conflict in representing both the Adamses at trial. Three, that the trial judge, who I believe was Judge Baxter,
Yes, Your Honor.
although this was a Judge Downs's case, it was Judge Baxter who tried it, that he committed error in admitting certain firearms evidence. for ineffective assistance, a subset of which is also number 2, which is the conflict. And then maybe number 5, which is this suppression of the fruits of the search of the Adams's home, where they found like your client in a duffel bag and some guns and things like that.
That's exactly right, Your Honor. On the motion to suppress, while not withdrawing that, I'd certainly reserve it if we end up in the state Supreme Court one day. I'm not going to argue that today.
Okay.
Mr. Strobel has some argument in that area, and I'm going to join that.
Okay, so I'll need to enter, you're not withdrawing it, so I'll need to, if I need to get to it, as I work through the issues, I ought to make clear in my order on the motions for new trial what I think about the lack of suppression of what was seized from your client's house.
As far as Leon himself, by himself is concerned, I don't know that that's even necessary. You certainly may, of course.
Okay.
But since it's not, it doesn't operate as a waiver upstairs if we don't argue it, however the court pleases.
Okay.
And this is one of the cases, and I don't do this always, when I will ask you to consider 13th juror review as well.
Sure. Well, and there all the fundamental grounds have been alleged, and I don't list those usually. Or when I say insufficient evidence, it's all those things. Any other grounds that there's nothing new? Sometimes a lawyer walks in and says, I was reviewing again last night, and there's some hearsay I want to complain about. Nope. Okay. Mr. Strobel, you inherited some arguments or grounds, and so I want to make sure you are maintaining them or not, and then you added a few. There was the motion to suppress that I've already talked about. That was ground 1. I think in your predecessor's motion, you're maintaining that.
Yes, Your Honor. I don't know if I'll argue today. I was researching the case recently. Originally, I didn't think I was going to maintain it. Last night, I was doing some additional research. I talked to Richard Scarborough. I don't know if it's, I think it was kind of argued wrongly. There's a James versus State cases that deals with cops securing a location in between the time, they get there and they're waiting on an arrest warrant, and it has certain extenuating circumstances have they met. So I'd like to have 10 days from today to brief that for the court.
Okay. Well, we can talk afterwards about what I'll hold off on and what I won't, because in part it may be that Mr. Armstrong's asking for some time to respond to several pleadings that came in more recently. The state's response was filed in a timely manner in June of last year, and then there've been some.
For the late filing of mine, Your Honor.
It's okay. You're new to the case. You have responded admirably to your recent appointment to the case, but you're not abandoning the challenge to the court's ruling where the court did not suppress the fruits of the search.
Yes, Your Honor.
You also are pursuing insufficient evidence. When I say you, a lawyer representing Isaiah Adams has argued that there was an error in imposing consecutive sentences on count 7.
I'm abandoning that, Your Honor.
Okay, good, because I don't think it would have prevailed. All right, so that's withdrawn. You have a bunch of grounds of ineffective assistance. We'll talk about those today. I didn't list them all because it would have filled a couple pages.
Really, it all goes back to the firearms introduction evidence, Your Honor. They're all kind of related.
Well, and so I'm gonna get to that. Apparently, there were 2 different witnesses. A witness, I think you pronounce it Rue. It's R-H-E-W.
That's what I can transcript, yes, Your Honor.
Okay, that's one person where you argue the court erred in letting some testimony come in about firearms.
Yes.
And then a Mr. Ward, who I believe is a cousin or some relative of your client. He also talked about guns, and you've objected to that. And then finally, the cumulative, a new ground for defense attorneys.
I also think it was technically it came under the testimony of the detective, Your Honor, but it's the guns that were seized during the search, not necessarily as fruit of an illegal search, but as 443 evidence and stuff that.
Okay, if it's in your motion, I'll respond to it. I may have lumped that into some of the other stuff. Okay, so I think I understand the universe of things, and I want to be clear. A decision not to argue a ground right now that you have pled preserves that ground. If you may say, as it sounds like Mr. Scarborough is going to do, I'm not going to add anything today. The words speak for themselves.
And Your Honor, I believe we also joined in on the conflict of interest.
That is front and center.
Okay.
That is front and center. Got that. Ms. Rivers, have you been able to hear Mr. Strobel?
Judge, I was just gonna ask that he move closer to the microphone.
You guys stay put. You don't need to move. It's just when you're talking, I'm going to actually have you come to the podium. It's going to be easier, or you're going to need to shift and be in front of the microphone that's there on the table. If sitting is fine, it's not a command that you stand, but the way we're laid out here, when it's your turn, Mr. Strobel, you'll either need to swap seats with Mr. Scarborough or come on up to the podium so Ms. Rivers can hear what's going on.
Your Honor.
Great. Mr. Armstrong, anything you want to add procedurally?
No, Your Honor.
All right, Mr. Scarborough and Mr. Strobel, but only one of you should answer this, and let's have it be Mr. Scarborough because he's closer to the microphone. Have the two of you agreed on how you're going to handle calling any witnesses? For example, we don't need to call Mr. Hudson twice, just once would suffice.
Not in detail. We have agreed that I'll probably present first, and I would imagine he would just inquire of Mr. Hudson after I do.
Okay, well, why don't we do that? So why don't you start, Mr. Scarborough, in any way you want? If you'll move the microphone a little closer to you, if you're going to do it from a seated position, you're welcome to go to the podium. But again, I don't require that. It's up to you.
I think I'll stand.
Okay.
Your Honor, before we take the evidence, I guess I would mention, it looks like there's a screen in front of the witness stand. Should I move that so that the defendants can see the witness when he testifies?
We can ask if that makes sense. I don't think we'll need the screen. The screen is super helpful when there's something remote or they're going to be exhibits. If they're going to be exhibits, then we need to leave that there. If there aren't going to be exhibits that the witnesses need to look at, then you're certainly welcome to move it. So my guess is that Isaiah Adams can see, but Leon may not. And so we'll move it. Thank you. All right, Mr. Scarborough, when you're ready.
Thank you, Your Honor, and good morning. Maskless okay while I'm here?
Please, when you're talking to the court, it makes sense if you don't mind, just because then it's easier for Ms. Rivers to hear, et cetera.
Right, okay. Well, may it please the court, we have, as you mentioned, several issues to get through, and I think this hearing might take a little while. I don't mean that in any extreme way, but we have a number of matters to inquire about. Just by way of introduction, while you've mentioned that correctly that there are a number of issues we're raising, there are really sort of two species of ineffective assistance of counsel that make up an important part of this case. One, and it's the lesser variety in this case, is the standard Strickland stuff that we're all familiar with. But primary in this case is the actual conflict argument, which is distinguished from Strickland, as you know, on the basis that reversal or entitlement to relief comes when there's an actual conflict that affects not the result of the proceeding, as in Strickland, but the representation itself, if there's an effect on the way the case is handled.
So let me ask you a question up front. Mr. Armstrong observed in his response that what you said is not that what you said is incorrect, but that you had flipped the analysis. And we're looking at, was there an actual conflict or not? And then only later, well, was there a waiver? Assume for a moment, I find there was a valid waiver. If I find that, does the existence of an actual conflict matter?
If you find a waiver as a formal matter, it would not.
So can we start with that?
Oh, sure, I will.
Okay.
The thing is that there are a number of instances of right to counsel issues that I've pleaded that are sort of both or can be viewed under either lens. So I'll just do that. Your Honor's aware, I think, of the facts from my at least from the sufficiency of the evidence brief that I filed a few weeks ago. This is essentially a shooting from one moving vehicle into another. I think the weight of the evidence suggests that a third party, Malcolm Pitts, who was tried separately from these gentlemen and was actually acquitted in a subsequent trial, was in fact the primary shooter, the person that the surviving victim.
Right, the cream colored sleeve sticking out the window. They find that hoodie in Pitts's house. It's got gunshot residue on it, et cetera.
Right, and that it was white actually, but yes. So that's the likely template in terms of what the facts actually were. And so issues like conspiracy liability, party to a crime liability come up a great deal. And I think that we have to look at these right to counsel problems in that manner, because if there was an action or an inaction undertaken by joint counsel that really affected the presentation of the defense with regard to party to a crime, say, that's going to be something that really mattered, was unlikely to be harmless.
I follow you and I'll cut to the chase. If I'm representing your client, I'm arguing a party to a crime is the driver of the car.
Right.
Isaiah, it's not the guy in the back seat who there's no evidence. I mean, his story doesn't check out. I didn't hear anything. I don't know anything. I mean, there's evidence out there that would cause a jury to say, I don't buy your story. Why are you hiding in a duffel bag? How could you hear nothing if 6 to 8 gunshots were fired? But setting that aside, you got the driver who is driving the shooter. There's your party to a crime. That's tricky to argue forcefully for both clients, because arguing for your client, Leon Adams, might be shining a pretty bright light on Isaiah Adams. That's your party to the crime, ladies and gentlemen. You should think about that. Maybe you convict Isaiah. I don't care. I'm not his lawyer. I'm Leon's lawyer. So I get all that. We don't need to spend a lot of time on the question of what would that conflict look like. I understand what it would look like. Hence, was there a waiver? Because if there was a waiver, then your client, with eyes wide open, made an interesting decision that had certain consequences that I may not be able to remedy.
Okay.
And if I don't mean to shortcut you, but I'm also, I think I get it. And so I'd love us to get to the areas where you want to present evidence and whatnot.
Understood. I wish you could represent him on retrial. That was very well articulated.
Alas.
Yeah, sort of a conflict there too. So, and I'll just close my introduction by saying, sort of putting the caboose at the front, that whether or not, regardless of the way you dispose of the insufficient evidence argument, and I hope you will find it meritorious, I at least wanted you to see that the evidence was thin, and certainly relatively thin as to Leon, such that if we do find error, again, very thin margin on which one could say any of those would be harmless. Now, there are things that will involve my kind of talking at you for a while, like the insufficiency argument. But as you suggested, I'm going to go ahead and just get to the conflict stuff because that's where the evidence is.
Okay.
And if I may invoke the rule first, and I'm first going to call Ms. Shonda Adams to the
Okay.
stand. Yes.
All right. So you'd like Mr. Hudson to be, I don't know who else you're calling.
Just the two of them and my client.
The two of them, meaning Shonda Adams,
And
Mr. Hudson,
right.
and your client. Your client can obviously stay.
Right.
So Mr. Hudson, if you don't mind, you can either go in the jury room or be outside, wherever you'd like to be. Great. Thank you.
And if Ms. Adams could come up.
Are you planning on having any witness look at something on that screen? Well, we can move the screen a little bit. That's how you need to not gesture to anyone. Okay.
Oh,
Thank you. The screen is how your colleagues will be seeing the witness. So I think we're going to leave the screen there.
Okay.
All right.
Go ahead.
Please raise your right hand. Do you swear or affirm the testimony that you share gives to the court the truth, the whole truth, and nothing but the truth, so help you?
Yeah.
All right, you may have a seat. Please state your first and last name, spell it for the record.
My name is Shonda Adams, CHANDA,
Thank you.
Good morning, Ms. Adams.
Morning.
And Your Honor, pardon me. I wonder if my client actually can see the witness. Can you see your sister? Okay. Okay. Thank you. We're set. Good morning, Ms. Adams. Do you know the two gentlemen sitting here with us?
Yes,
And how do you know them?
they are my brothers.
Okay. And which child are you in the line?
I'm number 2 behind Leon.
Behind Leon? Okay. And are you both older than Isaiah?
Correct.
Okay. Did there come a time when you were involved in hiring or discussing hiring an attorney for one or more of your brothers?
Yes,
Okay. And did there come a time that you had conversations with Mr. Dante Hudson about that?
yes.
How did that come about? How did you find out about him?
About Dante,
Mhm.
actually, Mr. Hudson's name was given to me by one of my brothers. That would be Isaiah.
Okay. Now, maybe prior to talking to him, had you done any shopping around on the internet or otherwise about what it might require to obtain counsel for your brothers?
Yes, I did. I didn't go too deep, but I did do a couple of searches online. Just
Okay.
Basic Google search.
Okay. And how did you find many lawyers that were likely to be within your family's financial reach?
Not at all.
Okay, okay. So when you first, with whom did you go to visit Mr. Hudson, if you did?
The first time we met him, my mother and I went.
Okay, and was that at his office?
It was, yes.
Okay, and at the time, was the thought that he might represent both of them or that he would represent one of them? Do you remember?
Well, the thought was that he would represent both. We had two, and he said that he could do both.
Okay. With regard to what you just said, did you have conversation among yourself, your mother, and Mr. Hudson about his ability to handle this serious felony case on behalf of two clients?
We did.
Okay. And what was the general nature of what was Mr. Hudson's general position on that subject?
His general position was that he could take on both clients
Okay.
without it being a problem for him.
Okay. Did you sort of quiz him about that a little?
A little. I just he said, this could happen or this could happen. He definitely suggested that we split the case from the third co-defendant.
Mhm.
And when I asked him, well, is it normal that you do, two people? And he said, oh, it's fine. He can handle both. So we didn't go back and forth about it too much. I just asked some questions based on things he said, and he seemed pretty confident that it would be fine.
Okay. Did you ask him to visit with your brothers in jail before he was formally retained?
I did.
Okay. And did he do that to your knowledge?
To my knowledge, because and forgive me, because it's been a while. We wouldn't have hired him without him doing that, because when he first came to us, or when we first came to him, I just kept saying to him, well, it's really my brother's decision. So I would appreciate if you spoke with them before we even go forward with anything, because that's what makes the most sense.
Okay. Did you make it clear throughout your conversations with him that you were in touch with your brothers and were communicating with them about this matter?
Yes,
Okay. And did you agree on a fee when he was finally retained?
we did.
What was that, if you remember?
It was somewhere like $7,000 or $8,000.
Okay. Would that be a piece or for the whole case?
That was for both.
Okay. That's the best of your recollection?
Yes,
Okay. And as we know, he was retained and continued on with the case. Is that right?
correct.
Okay. I have no further questions for you, Mr. Armstrong might, or Mr. Strobel.
Okay.
Ms. Adams, I want to follow up on one thing, and then I'll see if Mr. Strobel has questions, and then Mr. Armstrong. I think I heard you correctly, that Mr. Hudson's name came to you actually through your brother Isaiah.
That's correct.
You were doing your own research, but one idea, and the one that ultimately was the one your family pursued, came from your brother.
Correct.
Did he tell you he had already met Mr. Hudson, or he had just heard? What do you remember? Why did he give you that name, if you can recall?
From what I recall, it was just a name that someone else gave him.
Okay. And then you and your mother followed up on that.
Correct.
Okay, thank you. Mr. Strobel, do you have any questions for Ms. Adams?
Just briefly, Your Honor. Ms. Adams, I believe you said it was originally you and your mother that met with Mr. Hudson.
Yes.
Either one of y'all have any legal training?
No.
Okay, so y'all wouldn't know how to get into conflicts of interest and stuff,
No.
and y'all would have no way to evaluate his conflict based upon y'all's own personal knowledge. Is that correct?
Correct.
Okay. No further questions, Your Honor.
Thank you. Mr. Armstrong?
Is it okay if I stay?
It is fine. As long as you're using that microphone has a green light on it, you're welcome to stay right there.
Ms. Adams, good morning.
Morning.
I would like to ask you if your family hired Mr. Scarborough.
We did not.
Did your family hire Mr. Strobel?
We did not.
Okay. When you spoke with Mr. Hudson, y'all discussed the possibility of a conflict. Did I understand that correctly?
I feel like he gave us, like this could happen or this could happen. That was basically the way everything went the whole time.
So he discussed the possibilities of conflict with you and worked through that in your conversation.
basically, he said that there could be a conflict of interest, and I don't want to stand here and act like I have any verbatim statements from him, because I don't. It's
Okay.
been years.
Understood.
But I know that it had to be mentioned, and he just wrapped it up with, he was confident that it wouldn't be a problem.
Okay. I'm going to ask a couple awkward questions, and I apologize for that, but
Okay.
the defendants are raising a conflict issue.
Okay.
At any point in speaking with your brother Leon, did Leon ever say he was surprised because Isaiah started shooting?
Objection, relevance.
The relevance would be if there's an actual conflict, and this is a witness on the stand, y'all are asserting that there's a conflict between these two defendants that I'm not seeing yet. And so if one said, yes, I was doing nothing, and the other one started shooting and told this witness that, that would possibly give rise to a conflict that y'all would have.
That's very remote, and getting to the merits of who said what or did what doesn't.
I don't think it's remote, given what you have previewed to me in writing and verbally. You want to argue about the actual conflict that existed. I think it's an area that can be explored. I don't think we need to spend an hour on it, but I'm going to allow questions in that area. So if you'd repeat your question.
Absolutely. I believe I started with Leon. In your conversations with Leon, did he ever indicate to you that he was surprised during the event because Isaiah was shooting?
No.
Now moving to Isaiah, in his conversations with you, did he ever indicate that he was surprised because during this incident, Leon was shooting?
No.
If I could just have a moment to go over my notes, Your Honor.
Sure.
I apologize for asking those awkward questions. I understand. I have no further questions, Your Honor.
All right. Any redirect? None. No. Good. Okay. Ms. Adams, thank you so much for your time.
I will call Mr. Hudson, Your Honor.
Okay. If you don't mind knocking on the jury room door, oh, deputy will do it. Thank you. Okay. And so the record is clear. A benefit of the screen that may slightly obstruct some witnesses' view, individual's view of the witness. So hold on one second, Mr. Hudson. Is that on every other screen in the room now, the witness can very clearly be seen. So I noticed Isaiah Hudson looking at the big screen so he could see his sister, and eventually, it may have said Isaiah Hudson, Isaiah Adams, and Leon Adams quickly noticed that the screen on the desk in front of them shows the witness very clearly. So I think we're good to go, leaving the screen where it is. Apologize for interrupting.
Please raise your right hand. Do you swear or affirm the testimony that you shall give to the court is the truth, the whole truth, and nothing but the truth so much?
Yes,
All right, you may state your first and last name, spell for the record, please.
Dante Hudson, Dante Hudson.
Morning, Mr. Hudson.
Morning.
Thanks for being here and for your assistance throughout this case so far. Do you have the excerpts I handed you? Transcript
I
excerpts? Do
believe
you have them with you?
yeah.
You don't have them with you?
Yeah, I believe I left it at my,
Oh, may I get
Please,
them?
yeah, if you don't mind him going through your stuff. No, well, is it in the jury room or would it be,
I think it may be in the jury room.
oh, do you mind getting in there?
Yeah, it'll just be easier.
Sure, it'll be much easier. Bingo.
Thanks. Okay, Mr. Hudson, good morning. What is your relationship, if any, to the case of the state versus Leon and Isaiah Adams?
Former lead attorney?
Okay, and did you represent them at trial?
Yes,
Okay. And the transcript indicates that was a June 2018 trial. Does that comport with your recollection?
yes,
Okay. I presume you were, at the time of the trial or at the time of your representation, a member in good standing of the State Bar of Georgia.
yes,
And I presume that you still are. Is that correct?
that's correct.
Okay. When did you come into the case, if you recall? And I'll note that tab 1, I have a copy of your entry if you want to refresh.
I don't exactly recall at what stage the case was. It was sort of in a case management phase with Judge Downs, if I remember correctly.
Okay.
But not, I think the case had already been arraigned, so it was post-arraignment. Pre-motions.
Okay.
So somewhere in the middle there.
I'm going to want the record to be clear. I'm going to take judicial notice of a document from the docket. Mr. Hudson filed his entry of appearance in March of 2017, so a year plus before the trial. I appreciate you were answering where procedurally were we important, but I want the record to be clear. Mr. Hudson did not arrive on the scene 10 days before trial, but rather 14 months before trial.
Right. In fact, I was going to say, if you trust my math, and I tell you that would have been a representation of 440 days from your entry until the day you picked a jury. Would that sound about right to you?
That would.
Okay. What was the sort of mix or the characteristics of your law practice at the time? Let me ask you a couple of subparts. How much of it was criminal defense and how much was non-criminal defense?
About 95% criminal defense and the other 5% family.
Okay. Were you a so-called C3 or conflict attorney at that time?
I was.
Okay. What was the mix in terms of retained versus appointed cases that you handled, if you know?
Most of my cases were appointed.
Okay.
In terms of percentage, I would say maybe 75-25
Okay.
or 80-20, somewhere in that area.
Okay. And how about misdemeanor versus felony?
I maybe have one misdemeanor case.
Okay. Had you tried a murder case before this one?
Yes.
Okay. How did the case come to you, if you remember?
If I remember correctly, it was not a cold call, meaning just a random phone call to my office. I believe I was in court with Judge Downs on a different matter. And at some point, I don't remember if it was their mother or another family member, or I don't think Leon or Isaiah contacted me from the holding cell. But someone, one of those motions days or case management days, essentially kind of tracked me down and inquired as to, my credentials and so forth.
Okay. Before meeting the gentlemen who would become your clients, did you meet with any other members of their family?
I don't believe. I don't believe so.
Okay.
When you say meet, though, I guess I want to follow this. You said someone tracked you down, and it's someone who was a relative of the defendants. Tracked you down in person, because that would be a meeting. Tracked you down on the phone. That's a phone meeting. So make sure we're using the same terms here.
It was in person.
Okay. So you had some in-person interaction with someone who said, might you be able to represent my brothers, my sons, my nephews, whatever it would be?
Yes, it was a brief interaction, an exchange of information, and a follow-up at some point.
Okay. Did you have any prior relationship with the family?
No.
Okay. And if you recall, who broached the idea of your representing both brothers?
I want to say it was their mother.
Okay. Did you visit these gentlemen in jail before filing an entry?
If I recall correctly, I had a chance to speak with both of them at the same time in the holding cell.
Okay.
It was a brief interaction. I introduced myself, initially explained, what I do. And I believe at that point in time, they were wanting me to represent them both. And I think that was based on previous interactions, the conversations that I had with their mother. But in the holding cell was not, an appropriate time to have it extend the conversation about that. So we did not.
Okay. Did you settle on a fee for the representation?
Eventually, yes.
And what did that end up being?
I believe it was 11,000.
Okay. And was that per client or was that for the entire representation?
That
of
was
both?
for the entire representation, if I remember. Yes.
Okay. Tab 2 has a certificate of discovery, which is also on the docket already of the case. It's what I could find to be the discovery production that occurred prior to your filing of an entry. Okay, could you take a look at that? And seems to me this is a pretty good chunk of discovery, right? This would be a substantial amount of information about the case.
Yes.
Okay. Who was the attorney for these gentlemen before you were?
I don't recall. It may have been Kenya Bryant,
Okay.
but I'm not certain.
Okay. Did you obtain discovery from prior counsel?
I believe Kenya had, if it was Kenya, prior counsel did have some discovery that was provided to me. I believe I also followed up with the DA's office at some point regarding discovery.
Okay. How much of this discovery, let's say, that was produced to someone by the state, had you reviewed before you filed an entry, if you recall?
Only a small part. I think I reviewed some reports. I reviewed enough just to get a gist of the case to decide if even I can represent them both.
Okay.
So I did not dive into deep discovery because I didn't think it was necessary if I was not able to represent them. So I don't recall exactly what reports I looked at, but some reports, and spoke with family members who sort of gave me an outline of the case.
Okay.
And that was it before any hiring.
Okay. Did you dive into the videotape statements or anything like that at that point?
No.
Okay. Okay. Did you, by the time you'd filed an entry, did you have a sense of the relative strength of the evidence as between the two gentlemen?
A relative, yes.
Okay. Now, going forward, I'm going to just mention Leon because he's my client.
Sure.
I understand that a lot of this might have been done concurrently and would apply to both. But did there come a time when you discussed the risks of joint representation with Leon Adams?
Absolutely.
Okay. And what did you tell him about the possibility or the effects of joint representation?
Well, first I made it clear that this is not something that normally happens when attorney representing two clients. I had concerns about it. And I think that was sort of the extent of my initial meeting with Leon.
Would you have said the same thing? I'm taking notes. Would you have said the same thing to Isaiah?
Yes.
You wouldn't have said something different to one brother than you said to the other.
Not at all.
Okay.
Maybe it's easier for the court if I inquire as to both, just for the record.
Is that all right, Mr.
That's fine, Your
Strobel?
Honor.
You will be able to follow up as fully as you want, but I think it's clearer for
I
me.
think I also making this an easier stream of information.
Agreed.
Way you are.
So there won't be an objection if you're asking about interactions with both. It'll be interesting to hear if there were different interactions with them, but my notes are going to reflect, and it sounds like the record will, that you discussed the risks of joint representation, that this was not standard fare, that there could be some issues with both Isaiah and Leon.
Yes.
Okay.
Okay. Do you recall how many times, was it one time or more that you discussed this topic with them? Let's say prior to filing an entry, prior to actually entering the case.
I cannot give you an exact number of times. So I'm trying to think of at least an initial timeline. So I believe I spoke with their mother or a family member initially who tracked me down in the courthouse in Judge Downs. I believe after that, I spoke with both Leon and Isaiah. if I recall correctly, at that point in time, they were still in the holding tank from Judge Downs's hearings. That's my recollection.
Okay.
And I explained to them jointly, and again, not in any detail because we're in a holding tank, what I discussed with their mom. And generally, I don't represent two people, but I would hear everybody out. And I think that was the first two interactions where I discussed conflicts. At some point, I had a meeting with the family in my office. At the time, that was 235 Peachtree. That's where I had an extended discussion with the family about conflicts. I do not do that. And I explained why.
You said, pardon, you said you do not do that. You mean you don't jointly represent frequently? Is that?
I should say, I think I conveyed I'm uncomfortable doing that. Had reservations.
Okay.
And I've never done it before.
Okay. Now, the brothers were in custody at the time of that meeting at your office, right?
Yes.
Okay. And from what you said a minute ago, is it the case that you, when you were discussing joint representation with them, that it was always a joint conversation because they were in the holding tank or whatever?
No, it was not. They were on two different floors, if I recall correctly.
Okay. Okay. So this would be at the jail you're talking with?
Yes.
Okay. So you had separate conversations because they weren't?
Right.
Okay, fine. And did you ever have Leon or Isaiah or both sign anything indicating consent to joint representation?
I believe I did. I believe I did.
Okay.
If I did, it would be in the file, which I turned over to their mother, but to my recollection, I did.
Okay.
Your file went to your client's mother. Your file didn't go to Mr. Scarborough or Mr. Strobel.
No.
Okay.
Was the form, what was the form? Was it in the nature of an acknowledgement that you had talked about pitfalls of joint representation?
I don't recall the exact language in that document,
Mhm.
even if I did the document. But it would have been in the nature of I consent to, well, first off, I understand the sort of the dangers of joint representation, and I consent to waive any conflicts and have Mr. Hudson proceed. That's what it would have been.
Okay. Now, let me get a little grainy here. Was there ever a document proffered to them that sort of had the meat of the advisal written down? In other words, not just I've heard about the problem or the risk of joint representation and I consent, but was there ever a document proffered to them that was maybe a few pages and said, hey, these are the things that can go wrong. You may not be able to plea bargain as effectively, or you may be limited in closing or anything like that. I'm not trying to, to anything that was the substance of the warning as opposed to just an acknowledgement of the warning itself.
Okay. Well, first off, please keep in mind that I'm still unable to recall whether or not there was a document to begin with.
Okay.
I believe there was, but I'm not beholden to that.
Okay.
And certainly, I did not provide a multi-page explanation of the risk of proceeding with both defendants.
Okay. And did you ever suggest or offer to them an opportunity to speak about a waiver with any third-party lawyer, any independent counsel?
Again, recalling timeline. I believe I met with the family initially, right? We discussed the conflict issue.
Mm-hmm.
They did not pay me right then and there.
Mm-hmm.
So they had, knowing about the conflict issue, in my opinion, they themselves had the opportunity to go out and seek other lawyers based on my representation of my uneasiness with representing them both.
Okay.
I don't remember how much time it was between that initial meeting and when they formally retained me, maybe a week or two, perhaps longer. But did I say, you know what, you need to go out and find, or at least, no, I did not do that.
Okay, okay. And
I'm going to interrupt for 1 second. Did you ever counsel them not to do that? Hey, by the way, let's just keep this whole conflict thing between the three of us and don't ask anyone about it.
No, I did not.
So they were free to do it as far as you were concerned. You just didn't set up a situation where Jane Smith, a colleague of yours, could talk to them.
I did not expressly tell them to go out and look for other folks.
Okay.
I think that is implied, but
okay. Now, and to be clear, when we say they had time to do it or they were free to do it, that's a reference to the family, is it not?
yes.
Okay, okay. The family members who, of course, were not in custody.
Right.
Right, okay. Okay, I need to detour briefly to a matter you've been very candid about with me, and I'll be brief about it. Were you suffering from alcoholism during the course of your representation?
Yes, you can say that. Yes.
Okay. Had it been a sort of a longstanding problem?
It's off and on, but I think at that time, I was sort of in the deep of it.
Okay.
Fair to say.
Is it in the nature of that kind of problem that you flip a switch one day and you're impaired one day suddenly, or is it more of a progression?
It's more of a coping mechanism. And so when I would feel stress, not necessarily from work, that was relieved by drinking, and sometimes in, pretty copious amounts.
Okay. And is it the case with that condition or disease that the highs and lows are not always consistent? You can have good days and bad days. Is that fair to say?
Sure, yes.
Okay, okay. In 2018, did there come a time when you were actually, I believe, had a DUI and were produced in this court from a custody situation so that you could handle a case in the Superior Court of Fulton County?
Yes.
Okay. And if documents were to indicate that that was in late April of 2018, would that sound about right to you?
Yes.
Okay. So the transcript, I'll just indicate, transcripts indicate that the motion to suppress hearing was about a month later on May 31st. Agreed?
Yes.
And the trial was about a 1 week-ish trial that began on June 11th, 2018. Is that right?
Yes.
Okay.
The motion to suppress is what was found in the Adams household, or were there other motions to suppress?
That was it.
Okay. And Judge Downs would have heard that motion. Baxter's only role was trial judge.
Right. He just came in and tried the case.
Okay.
Okay. And did there come a time in another murder case around this time or somewhat after when I think Judge Millender asked you to withdraw because of the condition you were in at that particular time?
Yes.
Okay. And when, if you recall, approximately was that?
Maybe at the beginning of 2019.
Okay.
I'm not 100% certain, but that sounds right.
Okay. Thank you. Let's see. And was that sort of a low point?
Yes, you can say that. Yeah.
Okay. All right. Done with that. I'm going to move on now to some actions that you did or did not take during the course of the trial. Okay. Let's see. In a nutshell, a sentence or two, this is a homicide and an aggravated assault by gunfire from one moving vehicle to another. Is that a fair summary?
Yes.
Okay. How many indictees were there?
3.
Okay. And were they your two clients and a Mr. Malcolm Pitts?
Yes.
Okay. Do you recall, and it's okay if you don't, you recall what the evidence seemed to be, at least from discovery and then at trial, about who was sitting where in the car?
Yes.
Okay, please say.
Isaiah was the driver, Malcolm was the front passenger, and Leon was in the back seat.
Okay. Did you have a sense, what was your sense at the beginning of the trial as you stood up to try the case of the relative roles or culpability of the various people in the car, roughly speaking?
Well, first off, I thought of that way before trial.
Okay.
Actually, I thought of that before I took on representation.
Okay.
That goes back to me receiving documents, not everything, but documents enough for me to make an intelligent decision as to whether or not, there are conflicting defenses. And so when we're looking at the evidence in that, they were all in different positions in terms of the strength of the case against them and sort of the defenses that we could raise. In my opinion, Malcolm was the most culpable because the evidence showed, if I recall correctly, his hand, his arm out of the window. In terms of Isaiah, my course with Isaiah was, first off, he could not have been a shooter with his hand in front of Malcolm. But he did have some problems in terms of he was the driver. And I don't recall every action that took place after the shooting, but it sort of led me to believe that he could be party to the shooting by driving and his actions after driving, even if he was not the actual shooter.
Okay. How about Leon?
Leon, I thought was in a better position in that he was in the back seat. He was not driving anything. No one saw his arm out of the window. And so it was, he was just there. And I believe that I can argue effectively mere presence with Leon.
Okay.
Was there not, and this may have come out at trial, I'm just curious how, based on these questions, you navigated the evidence that there were at least 3, I think the firearms guy said there were like 100 guns fired. Obviously there weren't, it was 6 to 8, but it was some incredibly large number, but at least 3 guns fired. And so even if someone were to say it was Wild West Pitts firing 2 guns, you had a 380, you had a 9, and I think you had a 40, but there were 3 different calibers.
Yeah.
How did you weave that into the narrative of, well, Isaiah couldn't be shooting because he was the driver. Unless Pitts had a gun in his mouth, he could only fire 2 of the 3 guns. There's only one other person in the car. That's a problem for Leon. Was that, or I'm just curious how the range of guns that was used factored into your analysis.
So at the time I entered the case, I'm not sure, Bill, I'm not sure if I reviewed ballistics at that point in time prior to accepting representation.
But to be clear, I'm not asking this from a conflict perspective, more so this description of your observation that party to a crime could make life difficult for Isaiah, less so for Leon, but then there's that 3rd gun. I was just wondering.
And in discussing that evidence with both Leon and Isaiah, they and me sort of came to the conclusion that we argue that maybe bullets were out there already. I don't think that was a pretty strong argument, but based on the evidence and our position, that
Just a bad
that was the
stretch
best
of
we could
road.
do, yes.
Okay.
Okay. Did it figure in your planning for trial that Isaiah had also mentioned in a post-arrest statement, handing a gun to Pitts and then hiding a gun for Pitts?
I do recall the statement of handing the gun to Pitts. I don't necessarily specifically recall hiding, but Isaiah was pretty cooperative, so that wouldn't surprise me if that
Okay,
is actually what he said.
okay. Let me ask you this. Did you ever seek a plea bargain in this case?
Yes.
Tell me about that, please.
Well, at the time, in any homicide case, the standard plea offer from the district attorney's office is life. That's it.
Okay,
That's the offer.
okay. So that was the offer tendered, not one that you solicited, I guess. Because what's the benefit, right?
Right. That's their standard offer.
Okay. Are you aware of cases in this county that were indicted as murders but have settled on a lesser charge?
Yes.
Okay. Or on acquittal?
Yes.
Right. Okay. Generally speaking, when you take a case on, are you generally open to resolving a case by any number of means, dismissal, trial, plea, whatever turns out to be best?
Always. Yes.
Yes, okay. And no names, please, but have you ever in your career represented a client who flipped, so to speak, meaning they got a deal in exchange for testimony or information?
Yes.
Okay. Have you ever found in your professional experience that a client's willingness to take that route of cooperating might increase with the passage of time or with the learning of more information about what the government has?
I'm not certain I follow.
Okay. Have you ever been involved in a matter where client or clients were, let's say client, because you said this was a rare thing for you. A client on day one is like trial or bust. And then as discovery comes in and
Ms. Rivers, can you hear us again?
I can hear now.
Great.
Yeah.
Apparently our meeting was set up for only 1 hour. And so at 10:30, everything dropped, but we're back. I'll be adding a few of the other screens, but we can now be heard. And so if you would, I think Mr. Armstrong counted correctly, rewind by 3 questions and pick up, or Ms. Rivers, you may be able to tell Mr.
Yeah.
Scarborough what his last question was.
The last thing you said was, as discovery comes in, okay, question, have you ever been involved in a matter where clients, let's say clients, because you said this was a rare thing for you, a client on day one of trial or bust as discovery comes in and then it blacked out.
Okay, you keep a very good record. So you were asking, your client starts out saying, there's no way I'm working it out. And then drip, drip, drip comes the discovery and the client says, we need to resolve this.
Okay, yes.
So let's start there.
We got a little more than I thought. Okay.
Yeah.
So you've had that experience,
Yes.
right? Okay. And do you agree as a general matter that taking a plea can be in a client's best interest and in fact often is? Depending on the case.
I don't know about often is, but yes.
Okay, awfully general there. Now, have you ever solicited a plea bargain from the state, from the prosecution in a criminal case, rather than sort of passively waiting for an offer to be given to you?
Yes.
Okay. Was that option open to you in this case?
No.
Why is that?
If I recall, and I think I went through 2 ADAs with this case. At every point, if I recall correctly, when I asked if there is a way that we can resolve this without a trial, the answer was a consistent, our offer is life. And so if they were hard lined about that, no, I wasn't going to change that by saying, can we do 35 years under E?
Mhm. Okay. And it was, let me back up just a little. Why did they end up severed from Malcolm Pitts for purposes of trial, if you recall?
I do recall, it was out of convenience. I think Judge Baxter was there for trial. I think their attorney had a conflict. And so instead of going with all 3 together, it was Chinwe Foster, he represented Malcolm. So she was out on leave and Judge Baxter essentially said, well, these 2 are here, we're gonna go forward.
Okay. And I think I remember from the motion to suppress transcript, Judge Downs saying on May 31st that Judge Baxter would be trying the case. Is that right? Probably.
Yes.
It was known by then.
Yes, yeah.
Okay. And it was also known, was it not, reasonably in advance of trial, that there would be another trial of Mr. Pitts separately, at which the case would have to, the state would have to prove its case.
Of course, once they were severed,
Okay.
or once he was severed, rather.
Now, you didn't ever, now you've noted that you recognize an imbalance in terms of the strength of the evidence as between the 2 brothers. Is that fair?
Yes.
Okay. Did you ever go to the state and make an offer that Leon Adams would testify or proffer or anything against his brother in exchange for consideration?
No, I did not. And the reason is after conversations with both Leon and Isaiah, there was essentially a pact that, one would not turn against the other. And so if we have that understanding between attorney and client, I'm not going to go to the DA and say, can we do this anyway?
Okay. You couldn't have anyway, could you?
Couldn't have anyway. No, could not have.
Okay. Why is that?
Oh, that would present possibly conflicting defenses and other issues that would actually render me ineffective in the sense of whoever I had flipped, that would obviously adversely affect the other brother. And with my knowledge of, sort of both defenses and conversations with the other brother, and I'm not saying who are, but yeah, that it just would have caused problems.
Okay. And to cut to the chase, if I'm accurate here, don't let me put any words in your mouth. It would have been a bare conflict to deal one client
Yeah,
against the
yeah,
other,
yes,
right?
yeah.
And the thing is, that was not an option available to you, was it, from the time that you undertook joint representation?
But, I mean, can you like explain your question, please?
Well, in filing an entry of appearance on behalf of both of them, that foreclosed any ability to make such an offer, did it not? Now, put aside what they wanted at a particular point in time, but you just couldn't have done it during the whole 440 something days of your representation, right?
I didn't do it because it was the family's desire that I represent both of them.
Okay, okay.
Well, I want to make sure I understand that, but I want to pull apart a little bit something you said a few questions before. I thought I understand you to say, and it really didn't matter what I wanted because my clients, Isaiah and Leon, said to me in no uncertain terms, these are my words now, but I want to understand it, we're not cooperating against each other. It's not, don't explore it, don't do it, because I, Isaiah, won't say anything against Leon, and I, Leon, am not going to say anything against Isaiah.
Yes.
Okay, so whether you thought it was a good idea or not, your clients had said is not happening. Whether you could do it or not because of a conflict, they didn't want it to happen.
Correct.
Okay.
Okay. Do you remember talking to me and to Isaiah Adams' former counsel last year by Zoom?
I don't.
You don't?
I'm sure it happened, but I
Okay.
don't have any recollection of conversation.
Okay, I believe you were just audio rather than video, but do you recall a phone conversation with me and with Rich Merritt about the case?
I would have to have more details about the conversation. I'm not
Okay,
saying that it didn't happen, but I don't recall it.
okay. Would reviewing a Zoom generated transcript of the conversation refresh your recollection?
Yes.
Okay. Your Honor, may I approach the witness?
You may. That's not in, whatever you're going to share with him is not in
It's not.
this deck. Okay.
Okay, just reading from page 4 of this 11-page transcript. Could you, sir, review the 2 highlighted paragraphs quietly and just let me know when you're done? That's page 4. Sorry. that's-
Yes.
Okay. Does that in fact refresh your
Yes, I do
collection?
recall that
Okay.
conversation. Yes.
Okay. Did you tell us at the time, sir, that you weren't sure which brother was which, but you recalled a desire or tendency of one brother to protect the other?
Yes.
Okay.
I apologize, Your Honor. What page are we on?
Page 4 of 11.
Okay.
Yes, sir.
Is yours highlighted as well? So he's got what you're showing him, so he can read whatever paragraphs. Are you looking at the same? I just want to make sure you're looking at the same pages.
I believe I am, but.
Okay.
It's at timestamp 12:13 and then again at 13:57. Okay. All right, so this was in 2020. You recall now that anything about the conversation?
Yeah, I do. Yes.
Okay, that was 2020, right?
Yes.
Probably over a year ago?
Yes.
Okay, so you were that much closer in time to the events than you
Yes.
were today. And you were, of course, very professionally trying to assist us in the appeal, right?
Yes.
And you were trying to answer as truthfully and completely as you could to anything we ask. Okay. Did you say in part, during the course of representing them, I think it was, I sort of got the perception that Isaiah wanted to protect Leon more. And so there were conversations about, or maybe I have it backwards. There was one who was looking out for the other more so. And there were conversations about statements and trying to resolve the case short of trial, coming up with some sort of deal for the both of them. But ultimately, I mean, there were two things. One, the state never really agreed to any sort of proper deal or reduction or any sort of resolution that would involve maybe one having a lesser charge or a lesser sentence as opposed to the other. And two, what they said occurred that night never changed from the time that I first encountered them up through trial. And so based on pretty much the latter of those two, I felt fairly confident that we can present a good defense for both of them at the same time. So yeah, those sorts of thoughts came up, but there was really no productive way to pursue them, primarily because of the state. They weren't too terribly interested. Sound accurate? Okay. And again, you were barred from, regardless of what, withdrawn. If somebody had had a change of heart at any point in the representation and said, I want a deal, you still would have been ethically barred from offering information or assistance from one against the other. That's just ethics rules, right?
Yes.
Okay.
What would have, it sounds like that never happened. Is that correct? That neither client ever came up to you to say, you know what, I'm done protecting this guy. I'm going to protect my skin. I want out. I'll roll against Pitts and my brother.
Yes, that never happened.
Had that happened, what would you have done?
I would have withdrawn from both cases.
So that it could be pursued by another lawyer.
Yes.
Okay. Let me see here. Moving on, was it appears from the record and the discovery that all three indictees made recorded post-arrest statements, but that only Isaiah's was played at these gentlemen's trial, right?
I believe that's correct, yes.
Okay. And did Isaiah's statement, if you recall, include some explicit references to his brother Leon?
I don't recall exactly.
Okay. Did either of the Adams brothers testify at their joint trial?
No.
Okay. Are you familiar with the rule of Bruton versus the United States?
Yes.
Okay. Did you at any time seek redactions of Isaiah's statement to remove direct references to Leon?
I do not believe I did.
Okay.
I'm fairly certain that that I did not.
Okay. Was there any reason for that, or did it not occur to you, or what was the thinking?
Right now, I can't recall what the exact statements were.
Mm-hmm.
If I remember correctly, and once again, this is going off memory, I don't believe that Isaiah's statements regarding Leon were incriminating for Leon.
Okay.
I think they're actually bolstering,
Okay.
but I'm not, that's
Sure.
the best of my recollection.
Okay. Okay. And just for the record, did you ever move to sever the two brothers from each other?
No.
Okay. Let me direct you to pages 469 and 470 of the trial transcript, which is at tab 4. Here you're talking about to Detective Helio Garcia, who took the statements from both brothers. And you make some effort. I'll give you a moment. I'll stop yapping and let you review this in just a second. But you make some effort, even despite an objection from the state, to characterize Isaiah in his statement as cooperative And in contrast to Leon, who also gave a statement, but who you characterized as uncooperative. If you want to take a minute to just look at those 2 pages.
That was a fact of the case.
Okay. Well, what was your
Can you give me the name of the detective again?
Helio, Helio Garcia, Your Honor?
Haleo is part of the last name, or that's the
Sorry,
first
that's
name?
his first name.
Okay.
Okay, it was regarded as a fact of the case. Why did you engage in that questioning?
Well, again, Isaiah was in more peril, in my opinion, than Leon. A mitigation of his involvement with the case was the fact that he was, cooperative.
Okay.
I believe that was not necessarily for the defense, but actually for the jury. This is the jury trial, right?
Say that again?
Yeah, I'm just trying to make sure that this is trial.
Yeah, oh, absolutely.
Yeah.
And so your aim in engaging in the questioning that included the question and answer, and in your opinion, Leon wasn't terribly cooperative. Is that fair to say? Answer, I can say he wasn't saying the truth, correct? Not being cooperative, not being cooperative. That is a part of some questioning that you engaged in because you felt it was mitigating for Isaiah?
Yes.
Okay. And I will note on that same tab, tab 4, page 523 thereafter, a page of your closing argument at line 11 and 12. Garcia testified that in his opinion, Isaiah was cooperative, Leon not so much, but he also told you that that's his right. Would that have been motivated by the same reasoning?
Yes.
Your inclusion of that in the closing?
Yes.
Yeah, okay, thank you. Had you been representing Leon only, would there have been a reason to characterize him as uncooperative before the jury?
Well, I mean, the fact of the matter is, I don't believe he was cooperative.
Pardon?
I do not recall that he was cooperative.
Okay.
So you really can't dance around it. If I were representing Leon individually, I can't tell you what sort of course of action I would, excuse me, I would have engaged in to deal with the fact that he wasn't cooperative.
Okay.
It would have been different. I can't sit here and tell you today what it would be.
Okay. Is it the case that the whole notion of Leon being uncooperative was, to be blunt, that he didn't say a whole lot
Yes.
in his statement?
Yes.
Okay. Thank you. Do you agree that I think I might have asked this before, forgive me if I have, but do you share the view of the evidence that the person the surviving victim saw shooting initially with the first shot that amazingly happened to be fatal was in all likelihood Malcolm?
Yes.
Okay.
Well, you're closer to the evidence than I am, but I'm curious, how did someone conclude that the first out of 6 to 8 shots was the one that struck the victim in the temple?
Yeah, she said that as soon as she heard a gunshot, she turned to him and said, "Oh, baby, they're shooting at us," and he was gone already. So if it was the second shot or so, it was tragically accurate very early on.
But it wasn't forensic evidence that somehow it was the first shot.
No.
It's just based on this witness's testimony that there were a bunch of shots and I think it was the first, or it was early on. Okay.
And numbers aside, the evidence tended to show that Ms. Dobson saw the arm of Malcolm shooting, right?
Yes.
Okay, all right. Sorry to belabor that, but I just want to, okay. Unlike the state's very meandering closing, your 19-page closing statement nowhere mentioned party to a crime liability. It's at tab 6. That's the entire closing, if you want to look at it. But based on my review, I see a mention of conspiracy liability at page 532. But both by word search and by reading, I haven't found any reference in your closing to party to a crime liability.
May I have just a second?
Sure, and let me know if you concur after your review.
Your Honor, are we waiting for Mr. Hudson to read 19 full pages? Because I think the record will speak for itself.
I'd just soon he not read 19 full pages right now, but I mean, if you want to, I suspect Mr. Armstrong will draw your attention to where in your closing you did refer to party to a crime liability, if you did. So I will take Mr. Scarborough at his word that it's not in there. Maybe there's an allusion to something of that effect, but I don't think we need to have Mr. Hudson reread the 19 pages.
That's probably very fair, Your Honor. Thank you. Was there any strategy that you might have been that you were trying to advance by omitting reference to that topic?
Yes.
Okay, what would that be, if you recall?
I don't recall at this point, if I may.
You may.
Page 532, the first paragraph is where I talk about conspiracy.
Mhm.
I just started to read that part. I may be able to answer your question if I could just read that paragraph.
You should read what you need to read. I shared Mr. Armstrong's perspective that we might as well call it a day so you could read the 19 pages and we'll reconvene.
And I'm sorry, you should have had a chance to review it before we came to court, but I will tell you that it appears to me, look at whatever you need to. It appears to me that page 532 is the relevant page.
Yes, I believe so, yes.
Okay, what's your view now of that matter? After reading that, you recall, or did you see any reference to party to a crime?
I did not.
Okay, now,
I'm sorry.
go ahead. My questioning was confused. I'm sorry. So, did you say there was a strategy that you were trying to advance by omitting that topic from your closing?
Yes.
Okay, and what would that be if you recall?
To the best of my recollection, first off, I don't believe that the state had party to a crime as part of their primary case. I believe, based on the reading, that it was conspiracy of their theory of the case. And so my response to their theory of conspiracy was to kind of disengage that theory. I didn't believe that I needed to address party to a crime. I don't know why I would have, but that was my thinking at the time.
Okay, thank you. If Mr. Leon Adams was going to get convicted, it was going to be party to a crime or conspiracy liability. Is that fair to say?
If you were, yes.
Okay.
I guess that's your opinion. You and I have already had an exchange that there was testimony, there's evidence presented to the jury that at least 3 guns were used. And I've accounted for all the hands. And so the only available hand in the car, if there were only 3 people in the car, would have been Leon's hand. So I'm not, he can offer his opinion, but I guess I just don't understand your answer given the ballistics evidence that was that. I guess your defense was, you've explained that there were shell casings on that res, a bad road to ride down because there's shell casings all over the place.
Sure, and if I just may go a bit further.
Please.
Excuse me. Your question was if Leon were convicted by himself, would that be based on a conspiracy or party to a crime? I don't know what a jury would come up with and how they would come up with their conviction. So I can't really answer that. I believe that again, the state's theory of a conspiracy, the jury would have had to believe that in order to come to any conviction,
Okay,
whether it be Leon or Isaiah or Malcolm.
okay, thank you. Of course, we don't know what jurors do or think, or we're not in their minds, but that's your judgment or opinion, right? Okay,
Yes.
all right. Moving on, and I'm almost done. At tab 7, not the first page there, but starting at 556, 557, and again at 566 and 567, the state twice characterized Leon
Mr.
Adams.
Scarborough?
Yep.
Your tab 7 is in the 460s for me.
No, keep going. You'll get to it jumps to the 550s.
Yeah,
Ah.
yeah,
What
sorry.
were the pages again? I apologize.
Yeah, 556 and 57, and also 566 and 67. Okay,
And you didn't get to finish you said the state did.
yes, the state twice characterized Leon Adams' post-arrest statement in closing, despite declining to put it in evidence. Do you recall that?
Yes.
Okay, and when I say characterized it, I'll just read from the transcript here, starting at 556. I'm going to start at line 20, counsel. You heard one of the interviews completely, and I did not play Mr. Leon Adams' interview for you. It's very,
Don't read too fast. The
Okay.
court reporter can't keep up.
sure. And I did not play Mr. Leon Adams' interview for you. It's very long, and essentially, like you heard the detective testify, it's a lot of self-serving statements. Doesn't want to admit anything, sleeping the whole time. No one had a gun, no one. So I didn't want to bore you with all the lies. So I just chose to play Isaiah Adams' statement to you. And then going to 566. Let's see. One moment, Your Honor. Well, I may have grabbed the wrong pages. I'll just rest on the first one that I read. Did that seem objectionable? Does that seem objectionable to you now?
Yes.
Okay. Now there was some testimony from Detective Garcia about the content of Isaiah Adams' statement, wasn't there?
I'm sorry, if I can go back to your
Sure.
question.
Oh, go ahead.
I believe there were two sort of distinct statements. I think one about when I mentioned lies, right? And I think the first part was a bit different than that part. Am I recalling correctly?
So you just read what Mr. Scarborough just read was what the prosecutor said in his or her closing.
Her closing,
Her
right?
closing.
I'm sorry.
And so the question is, the question was, and you said yes, was that objectionable? This is a prosecutor saying, hey, I didn't give you this evidence, but let me tell you the evidence anyway.
Okay, first off, I thought that would have been in my closing.
Oh, sorry. I'm sorry. That's my fault, I'm
That's-
sure.
And I didn't recall, I thought that would be very odd.
Why he's like, wow, why did I say that? You didn't say that.
So yeah, I agree that I should have objected. The reason that I did not at the time is because of one, jury instructions in that closing arguments are not evidence. And two, the jury, they have their notes, they know what the evidence is. And so at the time, I thought that that's not really anything that I should object to.
Okay, okay.
Of course.
Let me ask you to look at the last 2 pages in the packet. At the bottom of 579 and going over to 580, it looks like there was something you wanted to put on the record at the close of the closing argument. Could you just look at those few lines going over to 580?
Which lines again?
Say 579, line 22, over into the next page.
Yes.
Okay, do you recall what that was? I mean, what that reference was to that would, well, withdrawn. That would have been a late objection, would it not?
Yes.
Okay. Do you recall whether that late objection related to the characterizing of the statement of Isaiah?
Yes, if I may, again.
Statement of
Of
Leon.
Leon, yes. Yeah, go ahead.
So when that statement was made,
Mhm.
I made the quick analysis that, closing argument, not evidence, jury has their notes.
Okay.
Pretty much almost immediately after, I began thinking that probably I should have.
Okay.
And that's why I wanted to go back and address that issue with Judge Dance.
Okay.
So almost immediately after I began Monday morning quarterbacking regarding
Okay.
that.
Gotcha. Finally, there happens to have been no motions for directed verdict in this case at the close of the evidence, either after, well, there was no defense evidence. Do you recall anything about why you omitted that or chose not to do it?
So
Okay. Do you generally make motions for directed verdict when the state's evidence closes?
generally, yes.
Okay. Nothing further, Your Honor. Thank you, Mr. Hudson.
So I need to do a time check with Mr. Strobel and Mr. Armstrong. I want to make sure you have as much time as you need to examine this witness. I suspect, Mr. Strobel, your questioning will be shorter because Mr. Scarborough covered a bunch, but you can have as much time as you want.
Pretty much, Your Honor, every question I was coming up with, Mr. Scarborough asked, right?
Okay, but let me just, we probably aren't going to finish today. I would love to finish with Mr. Hudson, so he doesn't need to come back. I didn't have my team get a time estimate from the lawyers. And so I have other court starting at 11:30.
Oh, gotcha.
So if we can finish Mr. Hudson without cramping anyone's style, let's do that. And if I'm a little late for the 11:30, they'll deal with it. But I think that'll be our natural break point, which doesn't preclude anyone from doing anything else. We'll just reconvene. We'll keep the Adamses here in Fulton County until we can do that. And we'll reconvene soon. It's not like, okay, I'll see you all in 3 months. I want to connect all the dots that you've already started laying out, Mr. Scarborough. I don't want to take up any more of that time. You can take a seat.
Yep.
And Mr. Strobel, you are up. Just know that as you're planning, if you can fit it in by 11:30, it's a natural fit. If it's not, we'll bring them back.
Thank you, Your Honor. Because I don't have many questions, especially regarding the conflict. I have a few questions that regarding ineffective and decisions he made during trial.
Great.
But just briefly on these, Mr. Hudson, I apologize. I had a chance to talk to you before today. I was just recently appointed to the case. You said you had, when you was initially retained, you had conversations with them about the risk of being joint representation. Is that correct?
Conflicts, yes.
Huh?
Conflicts, yes.
Conflict, yes. How many conversations like that did you have with them?
I don't recall the exact number of conversations. There were meetings both with myself and the family. I don't recall the exact number of those meetings, but at every stage, we talked about conflicts. And once I was officially retained, I believe that issue was put to rest.
When you were officially retained, did you have a complete discovery at that time? Did you have all of the police reports, all the forensics, all the interviews?
Well, I hadn't filed an entry, so I would not
Okay.
have that.
So you're saying the time you were retained, basically the conflict was put to rest?
Yes,
And you would agree that conflicts can arise as more information becomes available to you?
yes,
And did you have further, more detailed conversations about conflicts with either Isaiah or Leon after you received discovery?
no. And first off, their family was pretty determined that I represent both. And so, again, before I entered my entry of appearance, I had a chance to review some of the documents. I believe their mother had some reports. And I based my decision to represent both on the information that I had at the time. From that point forward, once I was retained, there was really no question as to whether or not I could represent both. And after I received discovery and went through discovery, I saw no conflicts. I actually saw two different defenses, and I felt more comfortable, and I explained that to the family.
Now, you said you explained that to the family, correct? Now, you agree you did not represent the Adams family. Is that correct?
I don't represent the Adams family.
No, you represented Isaiah and you represented Leon, correct?
Yes.
And you represented them both as individuals, not as a singular person or a single entity.
Yes,
Okay. So, and you never had personal one-on-one conversations with either one of them after you received full discovery?
That he didn't talk to them at all, or he didn't talk to them about conflict?
About conflict, Your Honor.
Okay, because my understanding is he had
I
plenty of
apologize
contact.
for the
Okay,
confusion there.
about conflict?
Yes, let's just assume, unless I say otherwise right now, I'm talking completely about the conflict of interest.
Okay. After I received full discovery?
Yes.
Yes, I had the conversation, and the conversation was, I believe I can represent both of you based on my review of the discovery, which presents two different defenses that do not conflict for each of you.
Okay. Like I said, we agree that Isaiah and Leon were not evidentiarily positioned on equal footing in this case.
Yes,
The evidence, in all honesty, was probably more incriminatory against Isaiah than it was Leon.
yes,
And if you're doing the mental calculus in math, let's make every trial decision is basically mental calculus of what is my risk versus what is my reward.
yes,
Probably you were considering, I think you said the possibility of Isaiah being convicted was probably higher than Leon.
At some point, I'm going to object to leading questions because this is the defense witness at this point.
okay. I think you can structure these openly. But do keep, it's a fair reminder that even though you didn't call Mr. Hudson, you were going to call
Understood,
him.
Your Honor, I
So-
was trying to,
But it's moving things along.
yes. And you agree with that, right?
I believe that there was more evidence, incriminating evidence against Isaiah than there was Leon.
And it might have been more beneficial to pursue a plea, even if it's a blind plea, with Isaiah than with Leon. Is that correct?
Objection, speculation.
Well, on your judgment, and as your experience as a criminal defense attorney,
A blind plea to life?
well, would you agree he actually faced more time than just life in this case?
I believe there were several charges which would lend itself to life plus, yes.
But the way this was structured, a blind plea would guarantee your client a life sentence. Unless the state was telling you, don't worry, we'll drop the murder charge and you can plead to the other things.
Right.
As I understand it, that was never offered to you despite you approaching the state about working things out. Right.
And in fact, in this case, he was sentenced to a life plus, I believe it was 15. Is that correct?
I believe so, yes.
And that could affect his overall ability to get paroled or anything of that nature. Is that correct?
Yes.
Okay.
Well, I don't know. Parole decisions are up to the parole board. My recollection is that I believe folks are parole eligible after 35 years or something like that. Beyond that, it's up to parole board. I can't say one way or another what they would do.
And even if Isaiah wanted to pursue a blind plea, would that have affected your representation of the entire case?
Projection, speculation. He's asking, would this have happened? Needn't ask, did this happen?
Let's focus on the dids. I think because this is playing back. Wait, but Mr. Scarborough was exploring this as well, but it was always in the context of, well, wait, did this happen? And if it didn't, then we don't need to go there. If it did, boy, we better explore that more.
Okay. Did Isaiah or even Leon ever approach you about pleas?
No.
Did you ever counsel with them about their best interest in maybe pursuing a plea?
I did not. There was two things. I don't recall that there was much interest in a plea. I could be incorrect about that on their part. But certainly with the state and their hard line, it would have been not helpful to do that.
Yeah.
Not productive.
Understood. I believe that Mr. Scarborough covered all my other questions.
Okay.
We
Well,
got
you
our
will be able
stories.
to rely on that same record.
Yeah, I would have a couple of questions. That's just in regards to the conflict. I'd ask you some brief questions in regards to ineffective and evidence decisions.
Certainly.
Mr. Hudson, you originally filed a motion to suppress in this case. Is that correct?
Yes.
And correct me if I'm wrong. Basically, your summary of facts, your basis was not that the arrest warrant for entering was valid, not that the search warrant was invalid on its face. It was that the officers from College Park in Clayton County were searching the house in the time in between the arrest warrant and the search warrant. Is that correct?
Yes, I believe that's
Right. So essentially, you're challenging basically the securing of the area in between the two warrants.
I was challenging the search of the house before there was a warrant.
So you're just basically, you always just challenged it on the searching aspect and you never challenged it on the alternative aspect that the house was improperly secured.
No, I didn't.
Okay. Did you ever argue that there were no extenuating circumstances that would justify securing the house or for the police to remain in the house?
I don't know that would be proper for a motion to suppress based on a warrantless search.
Well, like I said, we're not talking about the warrantless search. We're talking about the interim time.
Right.
And you agree police officers can take different actions in between that time.
Yes.
Your argument was they just straight up searched the property during that time.
Yes.
You never investigated the alternative theory that they weren't searching, but they were just securing the area.
No.
And you never asked the judge down in that case of the motion to suppress to evaluate the case based upon that aspect and whether that securing was illegal.
My focus was on a warrantless search.
Okay. So you never asked the judge to evaluate that, or you never researched that aspect?
No.
And apologize, I don't give me a second, I can tell you the exact site, but there's a case, are you familiar with a case called James v. State that came out in 2008?
Probably not by that name.
Probably not, yeah. Yeah, it's, or are you familiar with the cases or any case from the Court of Appeals or Georgia Supreme Court that deals with what officers have to prove or have to justify securing a scene while they went and obtained a search warrant?
Yes.
And what are the standards for that? As you understand them?
I mean, I can't recall right here. If I had cases in front of me, I mean, I'm not Lexus, so I can't,
Okay.
I can't answer that. But, you know, once again, my focus was on the warrantless search. And so, I mean, there was something else I should have focused on. I didn't, because I focused on the warrantless search.
All right, but let's say, well, let's just agree, you never focused on that aspect.
No.
Okay. You agree there's multiple ways to exclude evidence.
Yes,
And just because one way is shut down doesn't mean that another way is not open.
correct.
I just want to briefly go through the evidence at trial. First, let's talk about with the testimony. I believe his name was Mr. Rue. I don't know if that's how you pronounce his name, R-H-E-W, the owner of the 9mm gun that was found under Isaiah's bed.
I have some recollection of that.
If I may refresh your memory, just remember, basically the testimony was that his gun was stolen from him and that Isaiah's brother Xavier was the last one seen in the area. Do you remember that witness?
That sounds familiar. Yes.
Yeah. And you objected to that just solely on relevancy grounds. Is that correct?
If the transcript indicates yes.
Yeah. And I'll just ask the court to rely on the transcript. Unfortunately, I don't have.
It's okay. I'll certainly, you've raised it as a ground, so I'll be needing to look at that.
Now if you objected on relevancy grounds, basically you're saying it has no probative value, correct? Now you would argue, now the court overruled your objection, right?
If I recall correctly.
So the court would have found that at least there was some relevant probative value in to that gun, right?
Yes,
And you're familiar with 24-4-403, the exclusion of the balancing test of
Yes.
relevant evidence?
yes.
Did you ever ask the court to conduct the balancing test on that testimony?
Did I make a speaking objection?
Well, I mean, do you remember making one?
No.
Would you have had a strategic reason for not making that objection?
I objected based on relevance.
But you didn't object. But if the record didn't reflect a 403 objection, then you probably didn't make one, correct?
Question is why, I'm going to distill it for
Yes.
you. What I understand the issue to be is there a reason, assume you did not, is there a reason you did not make a 403 objection to Mr. Rue's testimony about his gun having been stolen?
Well, first, I believe the objection based on relevance goes to 403. I think it's 403. And secondly, Judge Downs, she made her ruling. And quite frankly, as you are doing, if there was an issue with that ruling in terms of whether or not she was correct, you would deal with that. And so that's, I guess, one aspect of it. And then, just frankly, I didn't think to make a speaking objection at that point in time.
So there was no reason for you not to make it other than you thought it was possibly covered by the relevancy objection, or you just didn't think of it?
I thought it was covered by relevancy.
All right. Similar questions, the next witness, Omari Ward, he testified about, I can separate his testimony in two parts. There was a part about what actually happened the night of the event. And then there was a section where he testified about a night of clubbing that happened about a week and a half before the incident. Do you remember that testimony?
I believe Omari was their cousin.
Omari is the cousin and manager
Yes,
of the nightclub? Do you remember that testimony?
not specifically, but I do remember his statements and testimony, yes.
And you remember him testifying about them brandishing guns or him observing them with firearms while they were out clubbing?
I believe so, yes.
And you objected that ground solely on relevancy.
Yes,
And just to speed this along, is the same reason you didn't make a 403B argument the same as the reason you didn't make it for Mr. Rue's testimony?
I believe objecting based on relevancy covers 403.
Okay. But just once again, there was no strategic idea for not making that objection.
No, the strategy is it was covered.
Okay. And I apologize. These questions are kind of repetitive. I kind of get
Sure.
break things down in multiple ways. And once again, now we're going to deal with the intro. I apologize. You remember when apologize, Your Honor. Sometimes my brain gets ahead of my mouth and I can't
Take
quite
your time. We're
to
we're
catch
good.
up. Next, I want to get into the firearms evidence or photos of firearms that are admitted through a detective at trial. Do you remember that?
Yes.
Now, before those evidence were admitted, do you remember renewing to Judge Baxter your objection in the motion to suppress?
Yes,
And you agreed that that objection would only cover whether or not the firearms were seized legally.
yes,
It would have no bearing on whether or not they were relevant to the case or whether or not their unfair prejudicial value substantially outweighed their probative value.
I did not make that objection.
And you agreed that that objection was not covered by the objection you made by your continuing objection.
Yeah, those are two different issues.
Okay. Is there any reason you didn't make an objection on those grounds?
Well, if the motion to suppress granted, then that evidence doesn't come in. So I guess I was looking at larger picture in terms of moving forward and not, I guess, wasting time. And that's probably not correct to say, but not raising what I would consider to be, a frivolous issue if the larger issue was the search.
So you're saying you agree that you could have got the evidence excluded if the judge ruled in your favor through 403 objections and relevancy objections?
Yes,
And you agree that the majority of the firearms were never connected to the shooting?
yes, I believe there were several firearms, if I recall correctly.
Yeah.
So that I have a little more context, this would have been someone from law enforcement narrating with some photos. Here's what we found in the Adams's house. Gun.
Yeah.
And maybe I'm making it up. There's a shotgun. There's
Yeah.
no evidence that a shotgun was involved in the shooting in this case.
Right. For
So,
Your Honor's example, they put photos of an AK, of a shotgun, of guns that were not connected to it.
okay, and so now I'm following a little bit more. These were things, all of which Mr. Hudson sought to suppress through the motion to suppress. That was denied.
Right.
So it's coming in. You're asking Mr. Hudson now, well, it's not fruit of the poisonous tree, so that means that it's not suppressed outside of trial. That doesn't make it admissible.
Right.
If they had found a mountain of stolen tires, that has nothing to do with this case, and arguably that's just bad character evidence. We're not going to let the stolen tires in. Guns is a different situation. But you're focused on why were there no objections to the shotgun, the AK, because weapons of that nature don't have a connection to the allegations in this case.
Correct. Your Honor.
Okay.
Yes.
So help me understand why you would not have objected. It sounds like you did not object. The record will speak for itself, to Detective so-and-so saying, oh, that's a photo of the AK that we found in your client's house.
I can't give a reason for that. I don't
Okay.
recall.
One other question. Do you remember during the, not one other question, one other line of questions. Do you remember during the testimony of Amari Ward, where he made a statement along the lines of, I think the state asked him, what is the context of the guns he observed? He made a statement along the lines of, They just looked like they were part of that lifestyle. Do you remember a statement along those lines?
If it's in the record,
It's, yes.
Okay.
And you actually objected to that statement. Do you remember that?
yes, I guess.
Your Honor, give me a second. I can pull it up, the transcript on my computer. I can show them the statement.
It's in the record.
It's in the record. Okay.
Okay, so you did object.
Okay. Do you remember if the judge ever, once again, I'm just going to paraphrase this to the record. The judge never actually issued a ruling on that. He just asked the state to move along. Does that sound consistent with your memory?
Well, assume that's what the record says, because
Yeah.
I'm not,
Yeah.
you're not gonna, I mean, maybe you remember something of that level of detail, but probably not, given the time that's passed. Assume Omari Ward said, yeah, those guys, your clients, they sort of live that lifestyle. You object, and Judge Baxter's response is to the state, move along.
Pretty much, yes.
Assume that happened. What's your
Okay.
question?
And that you basically objected that because of an improper character evidence. Is that correct?
Yes.
Did you ever, to your memory, ask the Judge Baxter to give a curative instruction of some sort, whether it's moving to strike the statement, curative instruction to the jury, or even the extreme one of asking for a mistrial?
I don't believe I did, no.
Okay. Would it have been beneficial to us, sir, for your clients to pursue at least one of those aspects?
Yes,
Do you have any strategic reason for not making that objection?
not that I can recall right now, no.
All right. I believe that's all the questions I have, Your Honor.
All right, I see what time it is, and I suspect Mr. Armstrong doesn't have 57 seconds worth of questioning.
I have more than 57 seconds, Your Honor.
Okay, so what we're gonna need to do, unfortunately, in particular for you, Mr. Hudson, is figure out a new date when you can be back, so that we can wrap this up. Because we're not gonna be able to finish today. It's my mistake, not anyone else's. I didn't think to ask the lawyers, how long is this gonna take? And no one has gone slowly in this. We're working through something that's important to do. Often motions for new trial take 30, 40 minutes. This isn't that one, and that's all right. So we'll need to reconvene. As I mentioned, the Adamses will stay in the Fulton County Jail. They won't go back to the state system. We will find our next available window that works for all three lawyers' schedule. I know we got a bunch of moving parts. And Mr. Hudson's, we're not going to assume that you're available just because we schedule a hearing. So it may be that Ms. Hansberry proposes a few dates, and then I'll ask you all to check your calendars and Mr. Hudson's. Is it safe to say, Mr. Scarborough, that the only other witness you would plan to call would be your client, who I can promise will be here when you're here?
There may be one further witness, but he would be brief.
Well, I'm not worried about the length. We will allocate a bunch of time for part two. I just need to make sure that person could be here on whatever day.
It would be an investigator from our office.
Okay.
On a small matter.
Person could be here. And Mr. Strobel, you planning on calling anyone else other than your client?
Your Honor, at this time, we don't plan on calling him, but that may change. between
Okay,
now
but
and- That would
he
the
can
only-
be here. He will be here.
To
You
my
don't.
knowledge, that would be the only witness that we would be calling.
All right. And Mr. Armstrong, were you planning on calling any witnesses on behalf of the state?
I chose not to do it today, but a slight possibility that I'd call the trial prosecutor, Nicole Finney,
Okay. Does she still work with the,
DeKalb County District Attorney's Office.
okay, so we'd have to check her schedule too.
Yes, but it's also, that's a low maybe. That's not a high maybe.
Okay. All right. So the main one is Mr. Hudson's schedule along with the three lawyers' schedule. We'll do that again.
I would just like to ask, I'll come close to this microphone. I generally consider the rules of reciprocal discovery to essentially apply to motions for new trial. And so there's the requirement of giving people's statements of witnesses about matters that are germane to their testimony. And so today we got one of those statements when Mr. Scarborough gave me the transcript that Mr. Hudson had on the telephone call. I just wanted to ask if there was any similar statements for the other witnesses that we were referring to, that I get those statements as well.
Sure. Just so you're in a position to have a meaningful cross-examination rather than on the fly reacting to something you were just handed.
Correct, because I am not a fast reader.
Okay, well, that's a fair request. Mr. Scarborough, do you have any other materials as you think through, I might call my investigator, I may call my client, that you think ought to be disclosed? And I'm not asking us to engage. Do the rules of reciprocal discovery still apply? I'm saying they do. And so I'm asking you / directing you to share with the state anything that you expect that you would be using to refresh recollection or use even more proactively, here's an exhibit.
Quick answer is no.
Okay, great. So Mr. Strobel, I assume your answer is no as well. If that changes, just make sure you get to Mr. Armstrong, whatever those records might be.
Understood, Your Honor.
And
Okay,
other than the transcript, I'm not aware of any statements Ms. Finney has made.
all right. Mr. Hudson, I appreciate your time. We're unfortunately going to need to bring you back here at another date. You're still local?
Yes.
Good. Okay. Well, we'll make it happen. The Adamses, you're going to be staying at Rice Street. We'll get you back here as soon as we can do part 2, and there'll not be 3 parts. It'll just be part 2 to this hearing, so that we can get closure on the motion for new trial, and then I'll be in a position to rule on it to figure out what's next for the 2 of you. If you've got any questions, your lawyers can come back and see you before they leave for the day. All right? And thank you to everyone in the gallery. I don't know how you did it, but you kept those little ones nice and quiet. They are welcome here every time. Oh, it's the phones. Okay. As long as they're quiet, you can bring them. Everyone be safe. Thank you.
Your Honor, may I inquire briefly? I mentioned prior to this hearing, wanted to explore the issue of an illegal securing of the area and the motion to suppress and ask for permission to file breaks.
You've got time now. So if there's something you want to file, I've learned the hard way that until I enter my order, a defendant can continue to add things. See Ken Shepherd. So,
I'm not saying I am going to, I'm just researching it. If it becomes necessary, then that's.
the clock works in your favor right now. The only thing that would allow me to say no would be if I enter my order. Until then, you can bring it up. I, of course, will turn to the state to say, would you like time to respond? If it's a legal issue, that really doesn't bother me at all. If you suddenly, I need to bring in 4 witnesses, then I might say, this was your chance to bring witnesses. You'd probably have to make a pretty impressive showing that here's why I only now realized I need these witnesses.
I guess I understand. Your Honor, at this point, I'm saying it just purely as legal argument.
Yep. That's fine. When you, and we haven't worked together before, I'm often fine with just, you need to read this case, Judge, and I'll look at the case. You're welcome to create a brief, but the case says what it says. I can read it and I'll agree with you or disagree. I'll distinguish it. I'll apply it, whatever. So I wouldn't knock yourself out in putting together a 10-page brief about one case.
Yes, sure.
Okay?
All right.
Mr. Armstrong,
Judge,
good to see you.
good to see you as well.
Not your case. Any idea how Pitts walked?
I did not read that transcript, and I don't
Oh,
think.
there isn't a transcript.
Oh, well, yes, he was acquitted.
He's acquitted.
Finney, I don't think tried the case.
Okay, so we don't have someone to ask what happened.
So I don't know what happened.
Okay,
It might be based on relative.
take care. Thank you for being here.
Yes, sir. It might be an example of why not to talk.
Yeah. And the value, my gosh, of that fortuitous severance that was sought by no one, but imposed by Judge Baxter. Yeah,
I've seen that happen a couple times.
I don't like that. Okay,
Have a good day, Judge.
thank you, sir. Hey,
Hey, Judge, what's our next matter?
I have nothing else. Oh, I do. In court at 1 o'clock. I'll be out here. I have a bunch of,
You have something back.
yeah, well, I'm gonna do it. I could do it right here, but it's all virtual. So I do it back there and take this off. But at 1, we've got a bench trial. I don't know if it's civil, so no one back there. I don't know if anyone's coming in. I will be out here and the courtroom will be open. So in theory, there may be some people coming in, but you're good till 1.
Okay.
All right, thank you.